My name is Daniel Wilson. This is Law Class 2150. Today's December 2nd, and I'm going to talk to you about the monetary benefits universities receive from student athletes. Who would like to see the benefits and monetary advantages because of what you have been a part of at this university? All of us do. Collegiate athletes feel the same way. Universities and colleges all around the nation are benefiting and making tons of money because of the popularity and success of the athletes attending their school. The prompt I will address is whether or not they should receive more benefits from their school and the National Collegiate Athletic Association, or the NCAA, or if things should remain the way they are now. Should collegiate athletes be considered employees of the school that they attend? Should they receive the same benefits that school employees receive? This relates to business law because of the legality of what is currently being enacted and whether or not it is unethical. The NCAA and colleges are seen as the booming business that seems to be the sole profiteers of collegiate sports. I'm going to show you what has been in the works in the past from a legal perspective and spread some light on how much profit is being gained by what some people would consider the wrong beneficiary. I found this image to be very interesting. As you can see, each university has a difference in the market value per player and what the value of their scholarship averages out to be. The difference is outstanding. The NCAA prides itself on the fact that college athletes should not be used for any type of monetary gain. With that being said, there have been numerous incidents where the jersey of a popular player has been sold to customers across the nation. The most recent example has occurred through a Wisconsin online website. The University of Wisconsin had a Melvin Gordon jersey on sale to the public. It is okay to sell the jerseys, but it is against NCAA rules to use any name. This just happened to occur after Melvin Gordon had a very impressive game the week before. Another example comes from Jay Billis' Twitter account. A little background on Jay Billis. He played basketball for Duke University and is currently commentating for ESPN. Along with commentating, Billis is a practicing lawyer. Jay Billis is always the first to criticize the NCAA, and on numerous on-screen appearances, he has said that college athletes should receive more benefits. The wrong that he points out is a picture he shared with his followers on Twitter. The image is captioned by Billis saying that players are not allowed to use their name and likenesses for commercial gain, but the NCAA can and does. Keller versus Electronic Arts was a court case in which Electronic Arts was using the likeness of football players in their NCAA football games. The plaintiff, who was a former college football player, and had filed the complaint. The case dealt with whether or not it was okay for EA to make the games without the consent of the football players that were being portrayed. The court ruled in favor of the plaintiff and held the First Amendment does not shield a video game developer from right of publicity claims when the depictions share many of the plaintiff's characteristics without much transformative modification by the defendant. Edward O'Bannon versus the National Collegiate Athletic Association was one of the biggest cases in regards to collegiate athletes and how they are being treated. O'Bannon was a basketball player for the University of California, Los Angeles from 1991 to 1995. O'Bannon alleged that the NCAA's rules and regulations constitute anti-competitive conduct. His reasoning for this came from a form that all student athletes must sign for the NCAA that states the NCAA would be allowed to use the student's name to promote the NCAA. O'Bannon was distraught and argued that in order for the NCAA to benefit from their image, that the athletes should enter into a licensing agreement with the companies that distribute products regarding that athlete's image. This way it would be beneficial to both parties and everyone involved. He was seeking benefits because his professional career was short-lived. The ruling in the O'Bannon versus NCAA case ruled in O'Bannon's favor and ruled against the NCAA in part. In O'Bannon's partial victory, the NCAA can now set a cap on the money paid to athletes as long as it allows at least $5,000 a year for big school football and basketball players. Although this was the ruling from the case, it has not been established for all NCAA schools, and schools have the choice whether or not they will participate in this ruling. There are many issues associated with this ordeal, one being antitrust laws. On the flip side of this topic is the fact that if college athletes were to receive monetary benefits, then colleges that have a prominent team could create monopolies. A college that is mainly known for their winning football team could bring in the top recruits and become the team that has no competition for years. The problem with this would be the loss of interest in sports. Knowing who will be number one at the end of the season is not as fun as watching teams compete and give their all in order to be the best. Players would go to the schools that have the most money coming in. Antitrust laws keep free competition in the marketplace. That means that the big teams have the same competition in regards to recruiting as the small schools. When you bring the monetary benefits into this situation, things will vastly change. Because of the rules that the NCAA has in place, student athletes leave their schools after a few years to pursue the money in professional sports. This prevents athletes from obtaining a degree and ends up hurting them if their professional careers do not work out. The NCAA has set rules that prevent athletes from coming into contact with agents for their professional careers. Along with that, college athletes are not allowed to accept any type of compensation. This rule is frequently broken, and some believe that it is an unreasonable restraint of trade, which is unlawful. Another legal issue is whether or not collegiate athletes deserve some sort of workers' compensation for their role within their schools. If the employees of the school receive benefits, then shouldn't the student athletes who are bringing in the most money? College athletics are seen as a job by anyone interested or involved in them. The amount of time and dedication that these men and women put into their sport is unparalleled to most jobs. They are students and athletes. They must attend class, do homework, play games, and practice on a daily basis. If they are injured, should there be some type of monetary settlement they receive? The debate here lies within the term extracurricular. If a student is working for the university, then they are eligible for workers' compensation, but if it occurs through an extracurricular activity, as sports are viewed, then they are not eligible. The head of the Big Ten said that his conference will likely cease to exist and the Rose Bowl would probably not be played. Jim Delaney said the idea of paying players goes against the entire college experience, and he couldn't see league members agreeing to it. He said that if some did, they likely would be kicked out of the conference because the move would create an imbalance among schools that could not be resolved. Many other college and conference administrators feel the same way about this issue. A lot of people feel that the current way collegiate athletes are treated is fair enough and that they shouldn't receive more than they are currently receiving. They believe that this method has worked for more than a century and that it will continue to work. People for this issue. Many people across the nation would like to see some type of change occur. The student athletes have the most support for this because they see the most change and benefits. From small schools to big schools, every student athlete would receive benefits from their role they have within their college. Also in favor of the change would be supporters and fans of these teams. Knowing your team is the best and they're receiving benefits for their success in sports, you would likely see an increase in the level of play within each game. This would increase game attendances, interest, and support from all types of fan bases. Some administrators and prominent figures in college athletics have stated that they are for a change in the way college athletes are treated. Jay Bilas being one of the most outspoken, as I have mentioned previously in my research. Personally, I think that there are positive and negative effects to a change. I do believe that college athletes should receive a percentage of what they bring into their schools, but I would not like to see all the best recruits going to the same school and creating dynasties and monopolies over every other school in contention. I think that there could be some type of implementation that would work out all the kinks and allow everyone to be happy. The current way collegiate sports are carried out, I believe, has little flaws, but I do see that change can occur for the better in order to make collegiate athletics more interesting. To conclude, there is a problem with the NCAA, the university system, and the student athletes. Student athletes should be entitled to more because of the monetary differences that schools in the NCAA pocket for themselves each year. What is being implemented today is unethical and illegal. Throughout time, there have been cases against the NCAA in order to motion a change, and nothing has come of it. I hope that I have educated you and made you a little more familiar with this topic. Now I challenge you to come up with your own opinion on this topic and help implement a change if you feel led. Thank you for your time today.